Testing, testing. Is that okay back there? Good morning, everyone. I'd like to welcome you all to this year's CIArb Young Members Group Annual Conference. It's great to see so many faces in the room today and have a significant number of virtual attendees joining us also on what is our first annual conference here in Dubai. My name is Michael Caddick. I'm a member of the Young Members Group Committee here in Dubai. I'm also Senior Manager at Kroll Expert Services. On behalf of the YMG Committee, we would like to thank you for joining us today, both in person and virtually. We'd also like to take this opportunity to thank our sponsors who have helped make this event possible. Clifford Chance, one of the world's preeminent law firms, with significant depth and range of resources across 5 continents. Kroll Expert Services, formerly BlackRock Expert Services, a premier provider independent expert analysis, testimony, advice, investigations for complex disputes and projects. DLA Piper, a leading global law firm with offices in more than 40 countries. CBBG Group, a construction expert services firm based in UAE, specializing in complex construction infrastructure disputes. And JS Held, a global consulting and expert firm providing specialized technical, scientific, financial, and advisory services. Today's conference will focus on arbitration in a changing world, with 4 key topics discussed and debated in detail by our guest speakers throughout the day. As you'll see on the screen at either side of me, we'll have today's program, whereby throughout the day, we'll be discussing this matter. We'll commence today with welcome remarks with a keynote address at 9:50 to 10:30 by our committee chair, Arun Viswers and our CR President, Anne Ryan Robertson. From 10:30 to 11:30, there will be a panel discussion on how arbitration has changed in the last decade, followed by refreshments. From 11:45 to 12:45, there'll be a debate on whether virtual hearings should be the default mode of hearings in the post-pandemic world, followed by lunch. After lunch, we'll have a virtual element of today, where there'll be a panel discussion on how arbitration will continue to adapt in the changing world, whereby our participants will be broadcasted to the room here in Dubai. Following a short break from 3:15 to 4:15, the day will then be concluded by a debate on whether the online identity of the arbitration practitioner is a help and not a hindrance. And finally, to close the day, there'll be opportunity to join us after and a committee for networking drinks from 5 till 7. For all sessions, there will be an opportunity for Q&A, and for those in physical attendance, please raise any questions at the end of each debate. For those who are attending virtually, please kindly raise your questions on the platform, and a member of our team will endeavour to liaise your questions with our moderators. Also, a word of warning, there's a cameraman in the room, Oliver. Oliver, please put your hand up. So if anyone would like any shots throughout the day, please get in touch with Oliver. I'd like to now take this opportunity to introduce our welcome speaker and our keynote speaker. Arun Viswers, who will deliver the welcome note, is the chairperson of our Young Members Group UAE Committee. Arun is a senior associate at Clifford Chance and has been based in Dubai since 2012. Our keynote speaker, Anne Ryan Robertson, is the president of the Chartered Institute of Arbitrators. Anne is also a partner at Lock Lord and acts as an arbitrator and advocate in international and domestic arbitrations. Among many accolades, a sample of Anne's recognition as a leading disputes lawyer comprises of being named in Global Arbitrations Review's Who's Who's Legal Arbitration since 2015, being named the best lawyers in America, International Arbitration Governmental since 2014, being named Lawyer of the Year in 2014 and 2017 in the same publication, and recognized by Women Attorney Foundation as Premier Woman in Law in 2020. Anne is also a member of various leading dispute resolution boards and its institutions, and is a founding member of Arbitral Women, and a former member of the ICC Commission on Arbitration. and is also a professor at the University of Houston Law Center, teaching advocacy in international arbitration. Firstly, I'd like to welcome to the stage Aaron Viswers-Warren to provide the welcome note. And also, I'd like to quickly ask everyone to turn their mobiles off or keep them on silent. Thank you.
Thank you, everyone, and a very good morning to all of you, both in person and those attending virtually. I wish I had all those accolades next to my name. Sadly, I can't profess to do that. But as the chairperson of the UAE Young Members group of CIArb, I'm honored to invite you all to the CIArb YMG's Annual Global Conference, and as Michael said, being held in Dubai for the very first time. At the outset, I must admit that we had two fortuitous moments which made this conference possible. The first, and I honestly can take no credit for this, it was in late 2019 that the Global Steering Committee of the YMG decided that the next annual conference would be held in Dubai. This was fortuitous given, as we've all seen, how well that Dubai and the UAE have managed to respond to the global pandemic, which has made in-person events like this and the rest of the events this week possible. Second, and me and my committee could take some credit for this, we decided a couple of months ago that we would hold an in-person conference in the hope that travel to the UAE would open up soon. This was when UAE was still on the red list to many countries. We are glad that our gamble paid off, and we have visitors from outside the UAE here today attending our conference and helping make this a truly global conference. The theme of this year's conference, as Michael said, is arbitration in a changing world. As you do as the chairperson when you have many other things to do planning an event, I put this introduction together late last night, and for inspiration, I decided to do a Google search of our theme out of curiosity. I was surprised to see that this was the title of an arbitration conference back in Bahrain in February 1993. And I say surprised because I honestly thought we had a unique theme. I was too young to even know what arbitration was back in 1993. However, the simple fact that this topic continues to resonate through the decades demonstrates the constant desire amongst the arbitration community to adapt to the changing world and the trends. And this is all the more important, I feel, this time around, in light of the seismic changes that the global pandemic has brought upon the world last year, and the changes the world has to tackle, such as climate change, the increasing use of technology, and the need to ensure diversity and inclusion. In fact, this morning I was looking at LinkedIn, and one of my inspirational models, Indra Nooyi, who used to be the helm of PepsiCo for years, she in fact said, inclusion is a mindset, diversity is just a program. So I'm glad that we are talking about diversity and inclusion today, and will be doing so throughout this conference. Today's conference will discuss three broad themes, by beginning with an exploration of how arbitration has changed in the last decade, and that will be the first panel of the day. We'll also be debating some of the issues of the present, such as virtual hearings and the online identity of arbitration practitioners, which will be later today. And interestingly, we're also going to try and gaze into the future with our crystal ball and most eminent speakers and see how arbitration might evolve from the perspective of the client, which none of us will ever forget, the environment, technology, and of course, all of us, the people, the practitioners. So we have a diverse and stellar lineup of speakers today, obviously me excluded, each of who are experts in their respective fields, and I'm looking forward to hearing them during the course of today's conference. At this point, I would like to thank my fellow committee members of the UAE YMG committee, without whose tireless efforts this conference would never have been possible. I can honestly say, hand on heart, that we've picked up some new skills along this journey that have potentially opened up new career options in event planning. And for Kyle, probably in Zoom technology. I must also thank the Global Steering Committee of the CIArb YMG, chaired by Laura West, who is here in person, who has flown all the way from the UK to support us, for guiding us in our efforts, and also the role of CIArb's marketing and administration team. Little did I know before taking on this role of the amount of resources that CIArb has and provides its members, particularly when you organize events like this. I sincerely encourage those planning to join CIArb to do so. I think you'll definitely get something out of it. And I'm not saying it because I'm standing here, but I honestly do believe that. Special thanks to each of our sponsors for supporting our efforts and whose representatives are here with us today and who I hope you'll get to meet during the conference. And last but not least, I'd like to thank all of you for joining us today. It is truly a sign of the changing world that we are privileged to have not just our friends and colleagues, all of you here in this room today, but also have fellow CIArb members dialing in from all over the world, viewing this conference from their respective countries. When I last checked, I think we had over 500 RSVPs split between in-person and virtual registrants for this conference, and I'm hoping to see more of them stream in during the course of today. Without taking up any more time, I'd like to pass this dais to our keynote speaker, Anne Ryan Robertson, who's the president of CIArb and has flown all the way from the US to support us. Thank you.
Good morning. I wish to thank the Young Members Group for inviting me here. My presidency began in January of this year during the height of the pandemic. And for a while, it looked as if I was going to be the Chartered Institute Zoom president. And over the last year, I have delivered many, many Zoom speeches, peering into that little camera on my laptop. And so this is the first time I've had an opportunity to address a physical audience. And I hope that it's a lot like riding a bicycle, you never forget. But I'm going to let you be the judge as to whether or not I still have the skills to address a group. The theme for today is arbitration in a changing world. And we're going to spend, as we know, quite a bit of time peering into the future. The English poet Lord Byron said that the best prophet for the future is the past. And that's where I want to begin today, the past. So let's turn to the past and focus on arbitration for a moment. It has a long and storied history. Scholars suggest that one of the earliest chronicles of arbitration was actually the well-known story of the prophet King Solomon. We all know the story. The two women come before him, each claiming to be the mother of the child. He makes his decision that, in fact, the child is to be divided, at which point one of the mothers removes her claim. And as the story goes, it proves that, one, she was the real mother, and the other thing that we take from this story is the phrase, splitting the baby, which has, since that time, underscored unfairly arbitral decisions. Significantly, in this instance, the arbitrator was a king. Much of the early arbitrations that we read about were decided by heads of state or by kings. It's for this reason that the Alabama Claims is considered a watershed moment in international arbitration. Now, those of you who are familiar with American history will know that we had a bloody Civil War, 1861 to 1865. And the northern states were called the Union, and the southern states were called the Confederacy. Now, the Union had said that the Confederates were belligerents, which is going to be a key component in what I'm about to tell you about the Alabama Claims. The North was blockading the various ports so that the South could not get its cotton and tobacco to Europe and could not get war materials back into the southern states. To divert the Union ships, the Confederacy hit upon the idea of attacking merchant ships, thereby diverting the Union's navy. The only problem is the southern states didn't have any ships. So they started looking for a supplier, and they looked to Britain. But there's only one problem. In 1819, Britain had enacted what is called the Foreign Enlistment Act, which provided that no British subject shall engage in equipping a ship or a vessel with the intent that such ship or vessel shall be employed in the service of a belligerent. Remember, the South is a belligerent. That should answer the question right there. But never underestimate the power of a legal opinion, because they were able to get a legal opinion from a solicitor named Hull in Liverpool, who had taken the advice from two barristers that it was okay to sell ships as long as they weren't armed. So the various shipbuilders went about building unarmed ships. The Confederacy purchased them, falsified the routes. For instance, the one we're going to talk about, the CSS Alabama, well, it was supposed to go to either China or Spain, but instead it went to the Azores, where it was manned with sailors from Liverpool and equipped with weapons. So, turns out the CSS Alabama was one of the most successful of the Confederate raiders. It burned or captured 64 Union ships and 1 Union warship. Other ships did similar damage. But it finally met its demise, and it met it in Cherbourg. And it was against the USS Kearsarge. This was a big event. It was in the newspapers that there was to be a duel on the seas. 15,000 people lined the shores. Edward Mamet, well, he immortalized it in his painting, the USS Kearsarge versus the CSS Alabama. And to this day, there is a song that is sung by sailors called Roll Alabama that also relates to this entire episode. Well, the USS Kearsarge was in much better condition, plus it had put chains on its hull and covered those chains with wood. And so it didn't take long before it was the victor, 45 minutes, in fact. The Alabama was hit on the starboard stern by a shell from a pivot gun. The steam pressure fell. Water flooded the ship, and the ship struck her colors. Now, by now, you're probably wondering, why is this Texan standing in front of me telling you about something that happened 150 years ago in the United States? It's because what happened after the Alabama claims that was unprecedented. Following the Civil War in 1869, the United States claimed direct and collateral damage against Great Britain. In the particular case of the Alabama, the United States claimed that Britain had violated neutrality by allowing these unarmed ships to, in fact, later be armed and knowing they would be used by the Confederacy. In 1871, the US and Britain agreed that they would create a commission in Washington comprised of 6 members from the British Empire and 6 members from the United States to resolve by treaty not only the Alabama claims, but also refinancing and other international disputes between Canada and the US. The result was the Treaty of Washington. Now, in accordance with this treaty, the International Arbitration Tribunal was established to adjudicate the Alabama claims. The tribunal, not surprisingly, was comprised of, yes, you guessed it, 5 men. 1 from the US, 1 from Britain, 1 from Italy, 1 from Switzerland, and 1 from Brazil. The US and Britain each had 1 representative, and appointed advocates. The decisions were given to the majority, and the award was to be issued within 3 months of the closing of the arguments, a structure that is somewhat similar to what we have today. The award was published in September of 1872. Britain was held unanimously responsible as to the damage that the Alabama had caused. As to the other ships, they were found liable, but it was in fact a split decision. The damages awarded. Well, you recall my telling you about Mr. Hall? Well, that advice turned out to be pretty expensive for Great Britain because the award was $15.5 million in gold. Today, that's worth billions. However, if you were to assume that in fact it was in dollars, it would only be worth about, and catch the only worth about $336 million, which proves what that banker, J.P. Morgan, always said, which was gold and silver are money, everything else is credit. So, what is the significance of the Alabama claims? It represents the first time disputes were resolved by arbitration. It represents the first time that the decision makers were not heads of state, but in fact experts in international law. And it is generally accepted that the arbitration of the Alabama claims is a precursor to the Hague Convention, the League of Nations, the World Court, and the United Nations. So now let's turn to the rise of commercial arbitration. Around 1870, there was a rapid economic growth springing from new innovations, including steelmaking processes, mass production, assembly line, electrical grids, and the large-scale manufacture of machine tools. This rapid economic growth is often referred to as the Second Industrial Revolution. And this revolution, of course, resulted in an increase in commercial transactions, and with those transactions, a need for dispute resolution procedures that did not involve the courts. It was against this backdrop of increasing industrialization that interest grew in arbitration, and 3 early institutions emerged, each a leader in the field of arbitration today. The first, the Chartered Institute of Arbitrators, 1915. Started by, you guessed it, 5 men, 2 solicitors, an architect, an accountant, and a surveyor, banded together to establish an organization with the aim to raise the status of arbitrator to the dignity of a distinct and recognized position as a learned profession. In 1979, it received its royal charter, and it has a public interest mandate to promote and facilitate worldwide the determination of disputes by arbitration and alternative means of dispute resolution other than resolution by the court. In the aftermath of World War I, there was no world system of rules governing trade, investment, finance, or commercial relationships. In Paris, in 1919, a small group of entrepreneurs decided to create an organization designed to represent business everywhere. And in 1923, the ICC established the International Court of Arbitration. In 1926, following the enactment of the United States Federal Arbitration Act, the American Arbitration Association was founded, initially purely domestic. In 1996, it established its international arm, the International Center for Dispute Resolution. Also in the 1920s, in 1923, the Geneva Protocol on Arbitration Clauses was concluded under the auspices of the League of Nations. The convention, ratified or acceded to by 30 states, was followed by the Geneva Convention on the execution of foreign arbitral awards in 1927. The continuing expansion of world trade and the acceleration of the commercial, acceleration of the commercial processes soon caused the business community to regard the provisions of the convention as inadequate. Great changes had occurred in international trade since 1927. Not only had the volume of international trade greatly increased, but business could now be done across borders that previously had been done within a country. At the same time, we had the emergence of new nations and less developed countries, and that too added additional complexity to the idea of trade. And not infrequently, nationals of one country were unwilling to accept the law of the country of the other party. In such cases, the parties settled upon some neutral place for arbitration. In doing so, they did not think in terms of litigation. All they wished to do was to dispose of their differences privately, quickly, and inexpensively, a wish that remains unchanged today. And thus, after much debate, conferring, and undoubtedly some wordsmithing, in 1958, the New York Convention was born. Today, with 168 state parties, the New York Convention is described as the most successful treaty in private international law. Excuse me. And now we reach today. There's no question that since those earliest beginnings, arbitration has steadily evolved, but the COVID-19 pandemic, which threw professional and personal lives into disarray, made Zoom a household world, and made "you're on mute" the most repeated sentence in 2002, has caused exponential growth. Much has been written regarding the arbitral community and how it met the pandemic-fueled challenges. Arbitrations that historically had been conducted face-to-face were suddenly conducted virtually. Questions swirled as to whether tribunals had the authority to order virtual hearings, and the Chartered Institute and the major arbitral institutions issued guidelines on how to conduct virtual hearings and to address the accompanying heightened possibility of security breaches. So what does that teach us? First and foremost, it teaches us that arbitration will evolve as society evolves. The onset of the Industrial Revolution naturally led to an upsurge of commercial transactions, and with it, disputes demanding resolution. Another key motivator, at least in the United States, for the rise of arbitration was the Second World War. The War Labor Board, during the Roosevelt presidency, insisted that both labor and management incorporate grievance arbitration clauses in collective bargaining agreements as a final and binding step of grievance resolution. The reason for this edict? So that the national and military production needs were not harmed during the war years. Most recently, the pandemic and how the arbitration community has rallied is a prime example of the lauded versatility of arbitration. Thus, one prediction, and it is indeed the easiest prediction to make, is that the arbitrations conducted virtually, at least in a hybrid form, will continue after the pandemic is over. The societal forces that are at work are many. Cost savings and reduced carbon emissions, to name but a few. Whether the format will remain the same with each counsel, party, witness, and arbitrator being in a different locale is open to debate. But what cannot be denied is, one, that virtual hearings make small claims arbitrations accessible and possible, and two, virtual hearings have the potential of fostering greater diversity and inclusion in arbitrator and counsel selection because the cost of travel has been eliminated. These virtual hearings, however, add an additional complexity to the question of witness testimony. Is it possible to determine the credibility of a witness simply by viewing that witness on the screen as opposed to in person? Arbitrators are of two views. Some continue to be concerned about the ability to determine if the person is being truthful. Others state that viewing a person on the screen results in the witness being much closer than the 20 feet away in a large conference room or hotel room for an in-person hearing. And there are others that say, well, when they're on the screen, it eliminates everything else so that there's nothing to distract me or to trigger some sort of unconscious bias. The recently issued ICC Commission report, The Accuracy of Fact Witness Memory in International Arbitration, further complicates the question of the reliability of witnesses. This report concludes that the memory of an honest witness can easily be distorted and may therefore be less reliable. Now, the report offers a variety of steps that may be taken to reduce the risk of witness memory distortion. But the result is that there is a very real possibility that the future will find more emphasis placed on documents, as in the civil law tradition, as opposed to the common law tradition that builds a case through testimony. Another prediction easily made is that massive document reviews will continue to be conducted using keywords for computer software to identify and extract potentially relevant documents, and legal research conducted electronically. Some argue that artificial intelligence will replace the role of the arbitrator. Others that while artificial intelligence, every time I see AI, I think of arbitrator intelligence, which I'm sure Catherine would be very pleased to know, will replace the role of the arbitrators. Others that artificial intelligence can provide answers, it can't provide reasons. Given that the international arbitration awards are to be reasoned, it can be argued that the role of artificial intelligence will play a limited role, at least for the foreseeable future, in the international sphere. But yet there is another issue, a vexatious issue, and that is the one of ethics. The difference between the positive duty of the United States practitioner to prepare a witness versus the more restrictive English approach and the even more restrictive civil law tradition highlights just one of the ethical differences international arbitration faces. There is also the overarching requirement of independence and impartiality and the call to eliminate the so-called double hatting. Independence and impartiality and the call to eliminate double hatting will continue. And because independence and impartiality is measured by that objective third party, there really is no universal definition. Although some have called for a universal code of ethics for arbitrators, 60% of the delegates at the Legal Business International Arbitration Summit said there was a no to having an overarching ethics body. The future, therefore, undoubtedly will require greater transparency and greater self-policing. An organization like the Chartered Institute of Arbitrators, with its code of professional conduct and ethics, to which all of its members are bound, will play an increasing important role in addressing the ethics question. In 2015, in recognition of the underrepresentation of women in international arbitration, there was the Equal Representation in Arbitration Pledge, which I'm sure all of you are well aware of, and if you haven't signed up, you should. The pledge has brought about change, primarily due to the efforts of the arbitral institutions, so there is much left to be done, particularly in educating the end users. Similarly, focusing on the lack of racial diversity is the Racial Equality for Arbitration Law, REAL. And initiatives such as the Pledge and REAL will continue to drive greater diversity on arbitral tribunals. And as we know, studies have shown that the more the diverse the decision makers, the better the decision. And then, of course, we have the recent United Nations Convention on International Settlement Agreements resulting from mediation, also known as the Singapore Convention. Still in its infancy, the Singapore Convention has been signed by 55 countries, but only ratified by 8. But its capacity to alter the dispute resolution landscape cannot be denied. Making mediated settlement agreements enforceable on a worldwide basis obviously could have the result of there being fewer cases arbitrated. And finally, we come to the issue of the types of disputes. At the forefront of the news is the specter of climate change. There is a heightened awareness of carbon emissions and the damage they wreak. The arbitral community is already addressing how to diminish the carbon footprint through behavioral change, as evidenced by the campaign for greener arbitration. On a larger scale, as society designs and implements the necessary infrastructure to support the efforts to address climate change, undoubtedly new and different types of disputes will appear. In addition, certain sectors will rise in prominence as society faces new challenges. For example, biotechnology and pharmaceuticals. As new industries gain importance, there will invariably be differing disputes and new arbitration sectors. But it is not only the new industries that will drive arbitration. For example, arbitration is increasingly a part of the strategic options considered for cross-border banking and financial disputes. There has been an increase in the number of industry-specific arbitration initiatives, including the introduction in 2013 of the ISDA optional arbitration clauses into the ISDA Master Agreement. 2018 saw the creation of the Court of Arbitration for Art. The Court of Arbitration for Art has rules specifically tailored to the industry. As members of its neutrals must possess either expertise in international arbitration or in art law, and the experts testifying, they're previously vetted, and they must be taken from that list of vetted experts if the expert is to opine on forensic science or provenance. And the expert is to be appointed by the tribunal. Thus, we will see not only the rise of business sectors, but also the continuing advent of arbitration rules tailored to a specific business sector. In conclusion, throughout history, arbitration has repeatedly and flexibly met societal demands. My prediction, it's an easy one. This adaptation will continue. While the traditional arbitration paradigm of all parties, all counsel, and the tribunal laden with hundreds of pages of documents, bound in bundles, huddled in a hotel room in some far-flung country, may rapidly become a thing of the past as we try to meet the specter of climate change and strive to become more efficient and economical. Arbitration as a preferred method of resolving cross-border disputes will continue. The arbitration trappings may differ in the future, but the result will remain the same: a just, fair, and equitable resolution technique other than by resolution by the courts, which of course is the mandate of the Chartered Institute of Arbitrators. Thank you for the opportunity to speak to you. I look forward to today's program and to hopefully having an opportunity to just speak to some of you personally. Thank you.
Thank you, Anne, and thank you, Aaron. An amazing speech in effort by Anne there for 30 minutes with a recently injured knee this week. So thank you. I'd like to now introduce our first panelist who will be discussing how arbitration has changed in the last decade. Lara Hamoud. Lara holds a position as Senior Legal Counsel at Abu Dhabi National Oil Company. Lara has been practicing international arbitration for 2 decades, acting as a chair of tribunals, sole arbitrator, and party-appointed arbitrator. Conrad Bromley. Conrad is a managing director of Secretariat, leading the quantum offering in the Dubai office. Conrad is a chartered quantity surveyor, practicing quantum expert. Conrad has 20 plus years of experience across various sectors and regions. Tom Montague-Smith, QC. Tom is a highly experienced advocate who has acted across the MENA region, appearing regularly in DIC courts since their creation. Tom has drafted the rules of the DIC court, the rules of the Dubai World Tribunal, and the rules of both the Court and Arbitration Centre in Astana International Financial Centre. And Paul Coates. Paul is a partner at Clifford Chance Litigation Dispute Resolution Group here in Dubai and has also practiced in London and Singapore. Paul advises on a wide range of international investment treaty arbitrations and has experience of advising on the rules of many of the major institutions. This discussion will be moderated by Aaron Viswers-Warren. As well as our YMG chair, Aaron is a senior associate at Clifford Chance and has been based in Dubai since 2012. Having previously worked in London and Singapore, Aaron specializes in international commercial arbitration and litigation and has acted on complex multi-jurisdictional disputes across a wide range of sectors. I'd like to now welcome our panelists.
Thank you. Can you hear me? Yeah, brilliant. Thank you, everyone, and thanks, Mike, once again for the kind introduction. So today's panel, as I mentioned in my introduction, we have a lineup of very experienced practitioners, and I'm glad I'm not in the speaker note because I definitely cannot say how arbitration has changed in the whole of the last decade. But you've heard the speakers, and so I'm not going to reintroduce all of them. But I'm going to go straight into just setting out the theme of how we're going to discuss today's panel. And I should note that we have time for Q&A at the end, both from any of you in this room as well as those dialed in virtually. If you put in your Q&A tab, I have managed somehow to get Zoom on my phone, so I will moderate and monitor your questions if you do enter them. So the agenda for this panel, and we thought about it a fair bit amongst this group, is we're going to initially discuss how arbitration rules and institutions have changed in the last decade, and then go on to discuss how the law of arbitration, including courts and the practice, has changed, then moving on to how arbitrator selection has changed in the last decade, and finally discuss the all-important topic of how the arbitral process has changed. So in the long-wanted tradition of ladies first, I will ask Lara Hamoud the first question, as she is, I think, best placed amongst this panel to answer this as well, given her extensive experience with the ICC and other arbitral institutions. So Lara, could you maybe briefly introduce to the panel and the audience how you've seen arbitration rules and institutions change in the last decade?
Sure. Thank you, Arun. Thank you for having me here. It's good to be having a conference in person and to seeing all audience in person as opposed to being behind your screen. So I'm very pleased. I would say that I've been practicing arbitration for 2 decades, and the last 10 to 13 years, I think, have been crucial to the development of arbitration in the region and internationally speaking. Arbitration has developed in a quicker pace. There have been new users became more involved, new players came into play. Some regions have understood the importance of having arbitration-friendly jurisdictions and have acted accordingly. And arbitration became more global. cross-border. And that happened really, in my mind, I think about 2007, 2008, that especially in the region. And I think the institutions had to adjust, had to adapt to these changes, to the criticism also from the users and the needs of those users. They had to adjust by expanding their presence, their interests internationally. Since 2008, ICC, for example, has opened 5 offices throughout the world, starting with Asia and Americas, and now Abu Dhabi. We know the LCIA, which came and got involved and had a presence in Dubai. But also, I'm thinking also of CIAC, the Hong Kong International Arbitration Center, which were more regional and became more international. So there was that kind of expansion, but also throughout the rules. If you look at the 4 leading institutions, or those who are among the most preferred arbitral institutions as voted in the survey, Queen's Mary and White and Case survey, you've got the ICC, the LCIA rules, the CIAC and the HKIAC. If you look at the ICC rules, for example, starting by 78, they were changed in 88, 10 years later, then 98, then 2012, so 13 years later, and then suddenly 2012, 2017, 2021. So they didn't wait 10 years. The LCIA rules, same, 85, 98, and then 2014, 2020. Same with the others. So in the last decade, there have been that need to adjust and to be proactive, not only react. Quickly, I would regroup, if you look at the innovations and the amendments of the rules, within the last decade or so, you can regroup them in 3 different, I would say, categories. The first one is more the focus that the arbitral institutions have put on the case management, on the effective case management, and on efficient proceedings. That was very important and crucial that the institutions focus on that. And we can think of for example, the provisions that give more powers to the tribunals to render procedural orders, and that where they consider appropriate to make procedural orders with regard to the fair, efficient, and expeditious conduct of arbitration. That was important for the institution to expand the powers of the tribunal in order also to face this due process paranoia that was, and still, they exist in arbitration. The expedited arbitration proceedings, that is an innovation. All institutions have now that procedure. The ICC was one of the latest to put them in the ICC in their rules. But today, they increased the threshold to $3 million for the cases who will be submitted to expedited proceedings. And it's an opt-in, so if you don't want them, you have to opt out. The other institutions have them in their rules, but it's an opt-in. I'm thinking also about the provisions relating to joinder and consolidation of cases. Also, the institutions have changed their rules in order to make those provisions more flexible and to give the tribunal, also more flexibility to decide on those consolidation and joinder in complex arbitration. The other category, quickly, where also the institution rules have, or on which they focus, is the transparency. There's this debate in arbitration between the need of confidentiality and the need of transparency. And the institutions have understood that they need to be transparent in many ways. You've got, for example, now in some of the rules, it is required for the parties to disclose the involvement of a third-party funding, in order to assess any economic interest of that third party. You also have, publication. I think it's very important. ICC is now publishing the awards with the names of the parties, etc., unless the parties object. But this is a great innovation that is giving the opportunity to arbitration to develop, to have a case law, a jurisprudence that will be developed. I'm thinking also of certain ICC courts decision that can be also, the reason of those ICC court decision could be, given and disclosed to the parties. And quickly, the technology, the rules have also obviously been amended to take into account the technology increase in the arbitration, the use of technology. I'm thinking of those provisions relating to, electronic signature of the award, the electronic filing, and obviously all the virtual hearing, whether guides or rules that were included in the rules.
Thank you. That's most insightful, and especially from you, given you sit as an arbitrator and you've been practicing with the institutions a fair bit. I noticed when you said technology, I see Conrad here has adopted that to the core because he's got a snazzy iPad for his notes. But coming on to Paul, you're a counsel, you've acted as law firm practitioner for many years. Which changes amongst the ones that Laura mentioned do you think have had the most impact in practice?
Sure, no, thanks, and good morning, everyone. Also very, very happy to be here today. And as Laura said, it's great to be here in person and seeing you all in the flesh, and look forward to meeting many of you later on. In terms of the changes that have had the most impact in practice, I think, Laura, you mentioned the words changes that have been effective, or increase the effectiveness of arbitration, and also changes that have improved the efficiency of arbitration. And it sounds slightly trite, but those are the ones I think that have been had the most impact in practice. I think in particular, one of those that has had a lot of impact, and perhaps if I'm being totally honest, more than I anticipated when it first came in, has been the introduction of emergency arbitrators. I think many people in the arbitration industry, and I would have to count myself among those, were slightly skeptical when emergency arbitrator provisions first came in, and really wondered how much they'd be utilised by the parties in preference to referring instead to the courts for interim relief. But actually, as those rules have developed and we've seen them more in play in practice, certainly when I'm handling a case and it is one where we need to consider interim relief, where that route is available is one that I'd very much consider. And I think there's a number of reasons for that. One is, and again, Laurie, you mentioned the confidentiality of arbitration. Going down an emergency arbitrator route allows you to preserve the confidentiality of your proceedings in a way that perhaps going to court might not. The other reason, and again you mentioned, Laura, is the global spread of arbitration. And I think there is a feeling that in certain jurisdictions you may be able to get interim relief more readily from an emergency arbitrator and perhaps more speedily than you would do in local courts. And certainly the evidence, anecdotal evidence, sort of bears out that emergency arbitration processes have been very much adopted by the parties, certainly with the ICC and with CIArb, perhaps more so than with some of the other institutions. I think the other changes, and again, Laura, you mentioned them, that have had a real impact sort of day to day, if you like, have been those that have recognised the sort of march of technology. So the fact that in many rules, electronic communication is now the norm, and we're not having to spend time printing out and couriering huge bundles of paper that then get marched into a hearing room. That has really impacted, I think, day-to-day practice, and also the increased recognition of virtual hearings. But I know that we're talking about that later, so I'll stop there, I think.
Yeah, we shall not step on to debate too. But Tom, if I can move on to you. So you have obviously acted as counsel in many hearings, both in arbitration and court. Do you have any particular examples that you'd see being embraced more than others amongst the ones Paul and Laura have mentioned, or any others?
Yeah, thanks, Arun. And again, very nice to be here. Nice to see everyone in person. This is the first time I've been in Dubai for almost 2 years, so it's great. I hope to catch up with some of you during the break. I think some of these developments have definitely been embraced more than others. Paul mentioned emergency arbitrators. I think most of us have probably now come across a situation where our clients have been engaged in that process, in particular jurisdictions where that is supported by the legislation in the jurisdiction, it's become particularly prominent, I think. But you do still see it in places like, including in here in the DIFC, even though there may be some doubts as to enforceability of those sorts of awards and precisely what you would do with it if the other side doesn't comply, but people are still using those. The other one, it's one of the things that Lara mentioned, was this development of rules on the joinder and consolidation of arbitrations, allowing multi-party arbitration and the joinder of related disputes, which solves a real practical problem that there was in arbitration. And even where the rules don't allow for the formal joinder, I see an increased appetite for example, the appointment of the same panel over related disputes between the same parties, and then a consolidation in effect, even if it's not formal consolidation under the rules. So I'm seeing quite a lot of that. Other procedures, though, that are available, I see them being used a bit less than one might expect. So summary determination, for example. I certainly haven't seen much appetite among arbitrators to use those sorts of procedures when they're available, and perhaps there's a little bit of conservatism amongst arbitrators, one eye on enforcement and a bit more caution when it comes to that sort of thing. For me, over the last 10 years, I'm not completely sure that there's been a sort of massive sea change in the way that people adopt and approach arbitration. Perhaps there's a little bit of scope for arbitrators to use the kind of the famed flexibility of the arbitral process a little bit more, in my view.
Great. I'm sure Lara and you will have a very interesting conversation after this panel. But if I can come on to you, Conrad, and being the quantity surveyor / expert on this panel, I'm not going to ask you how arbitration law has changed, but how do you see institutions helping experts? Has it changed in any way?
Yeah, thanks, Ru. The first thing I have written on my iPad here, written's the right word, is I'm not a lawyer, I'm a simple QS.
Okay.
So I'm not going to pretend to be one either, which is a hobby of some QSs. As a quantum expert, whilst it's important that you understand the specifics of the rules, the minutiae doesn't generally influence what you do, doesn't change how you discharge your duty to the tribunal. But that's not to say that the institutions haven't provided assistance or guidance over the past decade. On the 4th of November, so less than 2 weeks ago, the Academy of Experts produced the form and content of joint statements guidance for experts. Joint statements aren't new. From a UK perspective, of course, they've been dealt with in the Part 35 of CPR and Practice Direction 35, which governs discussions for experts. So it's not a new thing, but there's certainly a trend for experts to meet and to produce joint statements prior to producing your own individual reports. So that sort of guidance from the Academy of Experts, if you can call them under the broad term of institutions, is certainly welcome, and I think it helps to streamline the expert process. Similarly, we have guidelines for witness conferencing in international arbitration from our very own Chartered Institute of Arbitrators, published not too long ago, back in April 2019. And again, as with joint statements, witness conferencing, or hot tubbing as it's termed, it's not a new or revolutionary concept. I mean, as I think everyone will know, here it was started in Australia in 1985. Again, from a UK perspective, it was formalised in CPR in 2013. So it's not a new concept, but these guidelines are really helpful for everyone involved in the arbitration process. I remember within the last decade being asked by appointing solicitors, do you have any experience of hot tubbing? Now it seems to be universal. It's just a given that hot tubbing will occur. So I think these publications of guidance like this from institutions does help to formalise that process and give it a bit more structure. Whereas I think over the last decade it's been kind of a little bit ad hoc.
Yep.
So these sorts of guidances are certainly helpful.
Great. No, that's really interesting. I didn't know it was in 1985. That also probably tells my age. But moving on to a separate part of the agenda, And Tom, I'll start with you because you've helped shape some of the case law, at least in this region, if not others, around arbitration law. So could you maybe just very briefly, and noting we're 15 minutes into our session, so we have some time, but still, how has the law of arbitration changed in the last decade?
Thanks, Arun. Yeah, I mean, I think unlike perhaps my views on the way that procedures impacted things, I think 10 years really has been a long time in the development of the law of arbitration all over the world. I mean, it's easy to forget, but one of the most important recent decisions in the common law world on arbitration, the Dalla Real Estate case in the Supreme Court in the UK, is only 11 years old, and it feels like that's been around for a very long time. Here in the DIFC, I think virtually every case, not quite every case, but almost every case on arbitration in the DIFC courts has happened in the last 10 years. So almost the entire development of DIFC arbitration law, save for the legislation itself, has been in that period. And I think it was in sort of 2012, 2013 that we first started doing these claims to enforce arbitration awards in the DIFC. And we came up with the clever ways of the conduit enforcement, which perhaps caused more trouble than it solved, of bringing arbitration awards to the DIFC, and then using that as a kind of portal to then take them on shore and into the rest of the region for the purposes of enforcement. So there's been a huge development and ebb and flow in that particular area. But I think the DIFC is one example of a trend that you can see around the world, which is the rise of these independent, so-called offshore dispute resolution centres, of which there are now a few. We've got one in Abu Dhabi in the ADGM. There is the Singapore International Commercial Court, slightly different, but I've been involved in Kazakhstan with the Astana International Financial Centre. And that actually is a good example of how the development of those zones can really assist with the development of arbitration. So in the AIFC, I sit as a judge there. We've seen a few cases and there have been a few judgments. I think there's about 17 judgments now in the Astana court in the AIFC. But there have been 800 cases come through the International Arbitration Centre. That accounts for both arbitrations and mediations. And I'm not quite sure of what the split is there. But that's a good example, I think, of how the development of these international zones has also assisted in the development of regional arbitration in different parts of the world, and ensured that perhaps those cases which might have gone elsewhere or might have gone to local courts, parties now have the confidence to take them to arbitration, knowing that their arbitration will be protected by a modern legal system and independent judiciary. And the AIFC, a bit like the DIFC, in fact, the legislation in the AIFC is based on DIFC legislation. So this is model law development that we're seeing coming through, and obviously that has become more and more, I think probably not over the last 10 years, but it's certainly consolidated its position as the gold standard of the legislation. It's not universal though, and of course we've got a UAE arbitration law which is not based on the model law. But that, I think, also, that development reflects a regional change to the attitude towards arbitration. It's easy to forget that it was only in 2006 that the UAE actually signed up to the New York Convention, and only a few months before that happened, we had the Bechtel decision, which was obviously, quite a retrograde step when it came to arbitration. That's 2006, a little more than 10 years ago. And since then, there have been great strides forward. The arbitration law itself has been very well received as being supportive of arbitration. It has to be said, particularly in the Dubai courts, there have been some steps backwards. And so you get these one or two cases, particularly finding, for example, that arbitration agreements are void because the person who signed it wasn't properly authorized. Those have been difficult, I think, for some people. And more recently, I've seen cases where the courts have refused to enforce arbitration agreements in relation to disputes because the dispute is bound up with a wider dispute, and the courts have found them not to be separable. So it's not all steps forward. There have been the odd step back, but I'd say generally the signs are good, and that's regionally as well. And if one takes the example, for example, of Saudi Arabia, and remembers where they were with arbitration 10 years ago and where they are now, really embracing. It's been a real sea change in arbitration, perhaps not so much down to changes in the law, more changes in the attitude, changes in the decision-making that's going on in the courts. So yes, I think one sees it with the recent decree, which I'm not going to talk about today. I think some people would suggest there have been steps back in the way that law has developed. My view is that those are well outnumbered by the steps forward in this region, and it's this sort of conference taking place here is good evidence of the interest and support for arbitration that there is now in the region.
Yeah, no, I fully agree. I think the decree might come up at some point, but I shall not bring it up. No, but that's very, very interesting, because ultimately I think as legal practitioners, Paul, myself, some of those steps back are the loopholes we tend to somehow take advantage of at times, though I appreciate it's never great for clients and certainty of the proceedings. So Paul, if I can maybe then move on straight to you. From a practical perspective, how have you seen these developments affect our day-to-day practice?
Sure, no, thanks. Thanks for that. Yeah, as Tom said, the law really has changed an awful lot in the last 10 years, but both globally and regionally here in UAE and the wider Middle East region. And obviously, there have been this sort of swathe of new laws introduced, new arbitration laws in the UAE, in Saudi Arabia, elsewhere, but also the arbitration laws in AGM and DIFC. And obviously, as practitioners, we have to keep abreast of those developments, make sure we're advising our clients correctly, both in terms of managing an arbitration process, but actually also in making sure that the arbitration agreements that go into their contracts in the first place are fit for purpose. I think just to sort of focusing on that for a moment, I think that's really where our job starts. If you haven't got a valid arbitration agreement, we can talk about changes in the rules, we can talk about changes in the process as much as we like, but you need that sort of fundamental building block. And I think really, if we think about change in the last 10 years, there really have been over that decade, a number of case law decisions, a number of changes in the law that have arisen that have made us have to change the way in which arbitration clauses are drafted. And something we really need to sort of keep an eye on to make sure we are doing the right things. And just for a couple of examples in the last decade, if you think, well, certainly for me, if I go back 10 years ago, it wasn't that common to specify in an arbitration clause the governing law of the arbitration clause itself as distinct from the governing law of the contract. And then we had, probably going back nearly 10 years actually, cases like Sul-America, Arsenovia in the English courts, and then Enker and Chubb more recently, that brought up this issue where we have this sort of increase in arbitration continually, an increase in arbitration jurisprudence, and these issues are being sort of challenged more. And now it is clear that if you've got a separate governing law, if the governing law of your contract differs from the law of the seat you base your arbitration in, you really need to specify which of those two you want to go in the arbitration agreement, just so you have that certainty, but also just to avoid wasted time and cost for your clients fighting those out before they can get down to the meat of their dispute. I think another area where we've seen developments over the last 10 years, and frankly we're still seeing developments, is on the issue of unilateral option clauses. So a clause that offers one party, for example, the option to refer disputes to arbitration when the default position is courts. And I think we're continually seeing case law that tell us that actually some jurisdictions where we may have thought a clause like that would be readily enforceable, it's actually not the case. So I think France is probably the most cited example. In recent years, the Court of Cassation has issued a number of decisions that have made clear that actually, from a French perspective, there are issues with the enforcement of unilateral option clauses. And I think, again, as practitioners, we need to keep abreast of those developments and make sure we are advising our clients correctly.
Yeah, no, I think that's a fair point, especially unilateral option clauses. And on that, I must note the ADGM arbitration rules from memory. I think they included a provision saying unilateral option clauses are valid, which I thought was an interesting way to address it. Yeah. But Lara, if I can move on to you then. I know they've said a few steps forward, a few steps back, but is it fair to say there's a general pro-arbitration trend across the board when it comes to courts and States.
Yeah, I think no one can deny the fact that, there is a pro-arbitration, desire and actions that have been taken. If you look at the legislations in the region, most of them, if not all, have adopted recently, arbitration law based on new citral model law. I think Kuwait hasn't, but most of the jurisdictions in the region. So yes, and a lot of active initiatives have been taken accordingly. What I believe is that the legislation is one thing, but you also have, as Tom said, the courts following. And yes, there have been great cases, but the implementation of the law, which is a great law that has been, recently enacted in the UAE by the court, has not been as pro-arbitration as one would want. And I think the problem is that the courts here continue to look at arbitration as an exceptional form of dispute resolution. And as long as the courts would consider it this way, as opposed to an alternative form of dispute resolution, we would have decisions such as those that Tom mentioned earlier, which are steps back, unfortunately. Because it's all the perspective of the court and the consideration that the court would take by taking this decision will differ if it changes its perspective on arbitration. And we had, in 2019, a decision from the Court of Appeal of Dubai where it was expressly mentioned by the judge that arbitration is an alternative dispute resolution method and not an exception. But since then, we had so many courts' decisions saying again that it's exception. I think this is a perspective that needs to be changed for the courts to get more, into an arbitration-friendly mode. Yeah.
True. No, I think we can all honestly say we all hope that, and definitely I think there's a trend of that to come. Conrad, maybe very quickly, if I can ask you again, not asking a legal question here, but how is the experts work stream? Has it been changed or impacted in any way by law?
I'll be brief on this, because I was just short on time. Again, proceeding with a caution of a QS talking about impact of legal changes. By and large, what's been discussed here has very limited impact on a QS and a quantum expert. But I think worth mentioning briefly is, if everyone can cast their minds back to 2016, remember Federal Law number 7 of 2016, which concerned Article 257 of the Penal Code. This was thankfully resolved by Federal Decree number 24 in 2018. But I think everyone in the room understands the impact of that, the impact on experts and the impact on arbitrators. You could potentially be jailed, imprisoned, and there's no consequence at the time for any complaint made by a disgruntled party to an arbitration. For me, that was a real and obvious big step backwards that was thankfully remedied, that had an impact on experts and arbitrators.
I don't think you need to go in with the caveat of you're not a lawyer. That sounded very lawyer-like answer there. If I can then shift the discussion a bit further into arbitrator selection, because that's been, I think, if I'm fair to say, it's a very hot topic across the globe for a number of reasons. And without meaning to get into the discussion myself, maybe I'll start with Paul in this case, because as counsel, we are the first gating portal almost where it comes to deciding who the arbitrators we want to approach are. So how as counsel, law firm practitioner, have you seen that evolve over the last decade?
Sure, no, thanks for that. Probably the wrong answer. I didn't start with that. I don't think the process to select arbitrators has actually changed that much in the last decade. But by which I mean that when your client, a party is looking to select an arbitrator, I think as lawyers we still tend to think about the same types of criteria. So thinking about the nature of the issues in dispute, the industry sector you're working in, the governing law, the law of the seat, and potentially then the nature of your client's case. For example, is it a case that relies upon a strict interpretation of the contract? Is it a case that relies upon a more purposive interpretation of the contract and the surrounding facts? You may, if you're dealing, for example, with an investment treaty dispute, you may research a bit further into, say, a particular individual's views on jurisdictional matters to try and get a feel for where they might fall, or where they might conclude in relation to jurisdictional challenges. And I don't think those factors that help you select a candidate or the type of candidate you want have really changed that much in the last 10 years. I think what has changed quite materially in the last 10 years is the depth of the pool of arbitrators that is available for selection, and also the diversity of that pool. And I think there's a number of reasons for this, but when I sort of think back to when I started practicing, it felt like the world of arbitrators was really quite a closed shop. There was a relatively small group of people, usually white middle-aged men, it has to be said, that you would discuss time and again when it came to selecting an arbitrator for a particular dispute. As I say, that pool has deepened quite significantly, I think. And there's been a number of reasons for it. One has been the right sort of push to have a more diverse pool of arbitrators, and I'll perhaps come back to that in a moment. The other has been, I think, an increased awareness of issues of conflicts when it comes to selection of arbitrators. And I'm thinking in particular of conflicts that might arise because of the issue of repeat appointments. And we have now, they actually sort of predated the last decade, but you have things like the IBA guidelines on conflicts that have really sort of codified and crystallized some of these issues. And then they were, of course, updated in 2014. And so now we have some quite clear guidance about when repeat appointments becomes an issue that has to be disclosed. And that is, as I'm sure you're familiar, it's 2 appointments in the last 3 years is something that a potential arbitrator would have to disclose, and would then potentially be the subject of a challenge. And I think that has caused parties to look at a broader category. And also I think just the globalization of arbitration touching upon more jurisdictions, has also sort of deepened and broadened the pool. Just come back briefly to diversity, and actually Anne mentioned in her opening remarks that there has been an increase in diversity. I think there's still a fair bit of work to go. And to date, I think it's fair to say that the increase in diversity has been driven, again, Anne made the point herself, largely by the institutions themselves. And I don't know if we can just flick to that. You can marvel at my IT skills. Just some very simple statistics, and this is just looking at how the gender of arbitral tribunals has changed over time. And so we have some stats on the slides there, just from 2012. For the LCIA, we can see that only 10% of arbitrators appointed were female. That had risen to 33% in 2020. Obviously, a move in the right direction, but still a fair way to go to get the parity I think we all agree is necessary. But what is, I think, perhaps more interesting, and I don't know if you can sort of see them on the sort of far right of the slide, is the statistics around appointments by the parties and appointments by the LCI court in 2020. And we can see that whereas the parties only appointed 22% female arbitrators, the LCI court appointed 45% of female arbitrators. So it's clear, I think, there's a lot more work still to be done to educate our clients, and for us, I think, as practitioners, to take more responsibility for ensuring that we widen the diversity of arbitral tribunals. And at the bottom of the slide, we see the same picture for the ICC. I couldn't find stats going quite as far back for the ICC, but in 2017 it was 17%. In 2020 it was 23.4% female. But again, a real bias in the sense that it's the ICC court in that case that are appointing far more female arbitrators than the parties. So I think just come back to where I started. I think in terms of the issues we look at when selecting the type of candidates we want, I don't think that's really changed that much in the last 10 years. What has changed is the breadth and diversity of the arbitrator pool, but there is still work to be done there to, I think, increase that diversity, particularly by us as counsel and by our clients.
Great. No, I mean, these statistics were definitely eye-opening to me as well. But Lara, I think, I mean, you being a female arbitrator, part of the ICC court, how have you seen institutions? You know, I mean, it's obvious that institutions are doing a lot, but what more do you see, and how do you see it evolving?
I agree with Paul on the fact that the process hasn't really changed. I mean, if you look at the ICC, it's still going through the ICC national committees or direct appointments. Maybe now more options for the court to appoint directly, but the process is kind of the same now. Only 25% of the arbitrators in ICC cases are appointed by the court. So as Paul was saying, you've got 75% appointed by the parties. But what I can tell you is that the ICC court is definitely encouraging diversity, and not only the gender diversity, although it's a very, very high priority. But it doesn't, for example, appoint an arbitrator more than once in a year. So that's to broaden the pool. Also, in small cases, small value, not complex cases, the ICC rules would encourage the appointment, the nomination of young, arbitrators, as opposed to necessarily going to, very, very experienced. So that, again, to broaden the pool of arbitrators. And also the other thing that is I think, important when you are a court appointing arbitrators is that the database is vast. And so you can see who has been doing a good job and who hasn't. So that's also something that is taken into account when appointing, the
Great.
arbitrators.
And that leads me perfectly to the question I had for Tom, which, as Lara mentioned, how you perform as an arbitrator is very important. And have you seen that in practice?
Yeah, absolutely. I mean, I think the arbitrator's performance is the single most important factor in me putting forward someone for a new appointment. I mean, I am always looking for new arbitrators to appoint different, because as Paul says, I mean, there's a drive towards spreading it more now. You can't appoint people too many times. And so I'm always looking for people to go on my personal list of arbitrators, and their performance in the arbitrations that my direct experience of them is the single most important factor in me selecting them or proposing them. You're looking for someone who has appropriate expertise for that particular dispute, certainly, but ultimately you need someone who's going to do the work, who's going to be prepared, going to be thoughtful, careful, but who's also going to be open-minded, which one doesn't always find, but at the same time robust. Make sure that there's no nonsense and doesn't let the process drift, is going to drive it forward. And so, yeah, absolutely, the experience of that is the most important. You mentioned conflicts, and obviously the point of all of these rules about conflicts is to eliminate or try to eliminate bias or the appearance of bias. And I mean, I would say one sees it, but from counsel's perspective, any sense that an arbitrator is pulling for their appointing party in any regard, from my perspective, is just a line straight through them. So that is an important part of their performance as well.
Yeah, and you don't need to breach any confidentiality and mention names on this panel, but I'm sure you've had your war stories. Conrad, then maybe very briefly again, I personally have seen more and more experts being appointed as arbitrators. Is that a general trend in the experts world, and do experts wide to be arbitrators as well?
My experience is similar to yours. I think experts are being appointed more as experts. I think that may be tied to a parallel development that a lot of disputes are also being settled by dispute boards, by DABs, by DRBs, and maybe at that sort of level, the parties can gravitate towards a technical expert, someone they know, as Tom suggested criteria there, someone who really has the understanding of the matter in dispute, the technical expertise. Prior to sitting here, I tried to do some research to find statistics. Unfortunately, the only mention I found was in the Queen Mary University of London 2019 International Arbitration Survey, which was with Pinsent Masons. In that, 38% of the respondents said they had experience of appointing a technical expert to the tribunal. But over 50% also said they would be inclined to appoint a technical expert if they had expertise in the principal matter. So I think that bears our collective outlook that perhaps experts are being appointed more to tribunals. Unfortunately, I'm not aware of any other data that's recorded as to whether experts are appointed or not, unfortunately.
Okay. That's definitely very interesting. And then moving to the last segment, and we will have time for questions after that, is about the arbitral process, as I mentioned earlier. And I think that's obviously the hot topic in today's world, especially after what happened last year. But maybe I can start with you, Conrad, on this one. And maybe you can just give the expert's perspective of how you've seen things change in the last decade.
In the last decade, I think most of the changes we've seen are technological changes. They're born out of the technological advancements. We live in a world of unrelentless march of technology. It's pervasive in everything we do. So from an arbitration perspective, it's really two kind of categories that spring to mind for me. Practical development, so how all participants perform their role in the arbitral process, and process developments, how their processes and procedures have been changed or evolved by technology. Now, these might sound kind of trite, but this is my view of practical developments. A decade ago, if I was drafting an expert report as part of an expert team, say we had 5 people, that would involve 5 individual reports being drafted. And then when the deadline was due or a submission was due, you would all come together and kind of pull that into one document. And I'm sure everyone has their own experience, but that process is never straightforward. There's always formatting errors and formula errors, and it's a real time-consuming consequence of the lack of technology at that time. Whereas now, we all work on one single centrally stored document, and that's the only way it would work. It's so much easier. And that sort of collaborative working for me is a really obvious development in the last decade that makes my job a lot easier as an expert within the arbitral process. Also, data management. Again, it sounds kind of uninteresting, but a decade ago, my experience would be you'd be given racks and racks of hard copy project files. About a decade ago, I worked on a job where the employer met its disclosure obligations by producing a data room, just a room full of folders and a photocopier. And if anyone wanted information, contractor, experts, they had to go to that room and review and take away what they needed. It was a real manual process. I think from there we've moved slowly to soft copy documents, maybe in parallel with hard copy and sharing on hard disks and the like. To where we are today with sophisticated cloud storage and file management that allows gigabytes of data to be shared around the world in a matter of minutes. It's kind of an unsexy development, but it's one that really has an impact for me and I think everyone involved in the arbitration process. Some of the process developments, Paul, you mentioned earlier as well about the serving of reports and pleadings and how the rules have adapted to allow that. I remember printing out pages and pages in multiple copies of reports and pleadings and delivering them to DIAC and ADCAC. Whereas now it's our file storage and a simple email. It's a big change. Also, electronic bundles, I think, in a similar vein and perhaps accelerated by the pandemic, the move from hard copy bundles to electronic bundles. I think everyone involved in the arbitral process in the past decade will be able to picture vast shelves within a hearing room. Thankfully, that's a thing of the past and it's been replaced by this. There's an iPad. I have mixed feelings about those personally. I think it's great that they're portable, it's easy to share. It's obviously far greater for the environment, which is wonderful. But I think you lose the tactile feel that you get with a bundle. sit down and have your report in front of you. And often the software and being able to understand how to use the electronic bundles, I think that diminishes the user experience a little bit. But ultimately, that is the march of technology. That's the way we will always go. E-discovery, similarly, I mean, disclosure, document production, it's just document production in an electronic age. You know, it's a technological advancement only to the extent that that's the way we create and we store documents. We communicate with emails, Teams chats. So we have to move primarily to this electronic medium. And obviously, we can't discuss technology and advancements without mentioning virtual hearings. Again, not to encroach on the next debate, but and obviously accelerated by the pandemic. But I think virtual hearings are potentially here to stay. It's an immutable advancement that's been made. Yeah, that's kind of my experience.
Great. No, thank you. I think a lot of what you said resonates with all of us on this panel when we talk about technology. And you mentioned the employer case. I think that might have been a cynical strategy by the Employers' Council as well to make your lives difficult. But moving to Lara, and I think we're maybe in 5 minutes we'll wrap up for Q&A. So as an arbitrator, has technology helped in any way, or has it instead been a bane to your decision-making process?
Well, listen, just a story I just thought of when you were talking, Conrad, about technology. My office at home used to be full of boxes, and I had to buy constantly new bookshelves to put the folders, the A4 folders or the A5 folders, and it was really a mess. And I would really struggle once a case is finished, and I'm sure that nothing will happen after the award is rendered, to get like those shredder companies to come, because obviously you can't throw your documents in the bin, right? So, and it was costly, et cetera, et cetera. And now, like I recently moved, and my office, like there's literally no folders anymore. And obviously, you've got, but like everything is on screen, and everything, and I think this is amazing. I did struggle at the beginning because I'm a not like you, Conrad. But it changes a lot. So I think technology is great, but I think also it can be detrimental. I think arbitration generally is getting complex. We complexify it. We as parties, I think there should be the desire and the intention of the parties to try to go more to the relevant issues, to the list of issues, to the, so that is more important. And I'm hoping that technology will push parties, be more responsible. Sometimes technology is kind of detrimental because while you don't want to be printing 10,000 pages and send them to 3 people, you can throw 10,000 pages electronically by, so you really need, I think there should be an intention by the parties to be responsible also when using technology. One thing I would say, virtual hearing, I've been loving it because it gives you really more opportunities to meet with the parties. It's easier. And in terms of availability, it's much more, it's easier to be available for a virtual hearing. And I believe that the 5 weeks, hearings may be shortened when it's virtual to 2 or 3, because 5 years of being in front of the screen, I don't think it's human. So I'm hoping that would help. Yeah, but that's what I've seen so far.
I can see the next debate is the against team having a fairly tough job for all this after this discussion. But maybe briefly before we get on to Q&A, maybe Tom or Paul, I'll leave it to you who wants to answer. But Lara mentioned a very interesting point about this almost deluge of documentation. That's because when you put things on Word or PDF, there's no limit, Yeah. So do you see that in practice? Maybe briefly each one of you can mention.
No, please go.
Yeah. I mean, obviously, one of the consequences of the technology is that we're generating a lot more documents. So there's been an explosion of that, and it's not a problem that's specific to arbitration. It's a problem we're grappling with in the courts as well. So I did a case in the DIFC court, and we got a search order, and we seized about 12 million documents, at which point the other side said some of them are privileged. How are we going to do this? It was going to take 15 years to page turn every document. So technology was part of the answer. So we did a technology-assisted review where you have users are effectively training the AI to identify what are the privileged documents, and that process took about almost 2 years to get through it, but we're through the back end of that now. But it's a problem we're trying to grapple with in the rules in the courts in England as well. And the only thing I'd say is that in England we've developed now 5 different models of disclosure of more or less production of documents. About the middle is effectively what is the IBA approach to document production. That's the middle one of 5. And the only point I'd make is that in pretty much every arbitration I see the arbitrators resorting to the IBA rules, and I just wonder whether or not actually there's scope now to modify that in some cases, and even go for less document production. It's a flexible process and ought to allow for it.
Yep, no, that's 100%. And Paul, very briefly before we move to Q&A, so we had a discussion about social media, because it's obviously a younger audience. And everyone's on WhatsApp these days, including with clients. So is there a risk? Is there a risk when it comes to arbitration and things like WhatsApp?
I think there is a risk to an extent. And I think touching on sort of Laura and Tom's point, I think part of the risk is just in the sheer number of documents or materials that become available for disclosure. And I do think there is a need for greater discipline in order to make the process more efficient and not overly complex, unnecessarily complex. And I do often question, I think we have these huge disclosure exercises. How often is it out of that disclosure exercise that this sort of smoking gun emerges that makes or breaks a case? I would hazard a guess it's not that often. I think there is it needs to be more discipline there. I think the other risk, such as there is one, is really that I think a lot of clients are not necessarily aware ahead of time of the scope of the potential of document production or disclosure. I think clients, particularly if they've not been involved in dispute processes before, or perhaps they've only done it before the civil courts here, where there's not much in the way of disclosure, maybe have this notion that what gets disclosed, what gets produced, or what you're forced to produce, is the sort of more formal communication. So the letters on headed paper, the formal email communications, perhaps. I think people are often quite surprised to learn that your instant message chats, your WhatsApp messages, your handwritten notes, they're all disclosable. And we quite often give, obviously, Arun, you with me, sort of training to clients on this. And it's always that point in time when you start talking about document production, the arbitration process, you see the colour drain from everyone's face as they're thinking back of, oh gosh, what did I send you? I sent that formal email, but then I was sort of chatting on WhatsApp saying, well, actually, we can do a deal on this. We didn't really believe, the sort of the realisation that's sort of disclosable. I think as practitioners, there is, again, a sort of a slight duty on us, I think, to educate our clients ahead of time as to the scope of potential disclosure, rather than on the day that arbitration commences, because by then it's often too late.
Yeah, no, it's very interesting, and I'm sure a few people have been caught out by WhatsApp or instant messaging generally. But I think we've had a very interesting and insightful discussion. It's time for questions and Q&A. Let's see, we've got one here, and Michael will come around with a mic, so the people on the virtual can also hear you. And equally, if anyone dialing in virtually want to put in your Q&A, feel free, and I'll pick it up from the Q&A tab. Mike, this gentleman here.
Sorry, can you raise your hand?
It might be nice if you also introduce yourself, so it'll be good for you.
My name is Joe Kelly. I'm a quantum expert in the similar field as Conrad. In the last 10 years, do you think the role of the expert has been enhanced, diminished, or treated very, very much down the line? Namely, in the protection of the expert, and the duties of the expert is to the tribunal, but the fact is he has to get paid by his appointing party. Whereas appointing party doesn't pay. In the fact of the arbitral panel, they are protected in such a way that the other party may pay, but the expert is not. But the expert still has a responsibility to a tribunal and has to be left out in the cold. What's your views on that?
Good question. You can never diminish the expert's duty. The expert will always have a duty to serve the tribunal. To the extent that an expert is appointed by parties and the fees aren't paid, I'm not sure there's really a solution. I know experts who would threaten to not turn up at a hearing, but that's a surefire way not to be paid. Perhaps the solution is to move towards tribunal-appointed experts, and the experts are paid as part of the tribunal fees as well.
Would you consider that an escrow account to protect the fees, or the fact is they have to lodge security on the fees to the tribunal, and basically the tribunal can sort the fees out? This is a point for
I think it's a matter for the. I think it's a matter between the expert and the party that's appointed them, isn't it? I mean, as counsel, we're often in a similar position. We have duties to the tribunal just as we have duties to the court. So I think and there are counsel who will refuse to prepare unless they're paid in advance and all the rest of it.
I think that's right. I do think there's only so much that a set of rules or a tribunal can do to protect them. It's really a matter for the counsel and their client, or the expert and their client. And as you say, there may come a point in time where you say, well, actually, I'm sorry, I'm putting my pens down on this. That's really it's more of a sort of commercial issue, isn't it, than anything else? But I do sympathise if that's a.
But the fact is whenever you see one side, especially that the actual rules of the arbitration protects, for example, one party arbitrator in the event of non-payment that the other party pays for him. Why should the expert, who is in the same duty to the tribunal, not protected in a similar way by the institutions with the rules, etc.? I think that's very difficult, because unless you're talking about a tribunal-appointed expert, as Conrad says, if you're talking about party-appointed experts, that is a choice by the parties. There are experts within different price brackets, same as there are with counsel. I think it's very difficult to say, as a party, right, I'm not going to pay for my expert. That means other parties are going to have to pay for them, no matter what fee agreement I have reached with them. And I think we've all seen it in practice when it comes to the tribunal's fees and the institution's fees, that some recalcitrant, normally respondent parties, will use that as a tactic to place more pressure on the claimant by refusing to pay and forcing the claimant to put their hand deeper into their pocket to pay the fees. I think if you were to then introduce sort of experts' fees, lawyers' fees into the mix, you just sort of widen the scope for that. I can't see it happening realistically in practice. The arbitrator is appointed by the party.
If I may,
the fact is, does an expert and arbitrator not have the same status?
I think if I may, and this is my 2 cents, I think this might require some collective thought as experts' bodies, or recommendations to institutions and so on. So if, as everyone says here, I think you can't expect the parties to do something on their own, or the tribunal, because they all have their rules. But I think definitely some food for thought. If I could maybe ask others if they have any questions.
Thank you very much.
Thank you. Mike?
I hope it doesn't happen often.
Yeah.
I think that might be his issue.
Good morning. My name is Hassan Arab from Al-Tamimi & Company. First of all, I would like to thank the panel for the lovely discussion, actually. There are lots of topics they highlighted, but I would like to focus on one where they talked about the recent developments, or the developments in the past 10 years. And part of the things which I would like to comment here, I totally agree with with Lara, where she said that part of the issues that we are facing with the wrong decisions is basically that the court is still, they expect the arbitration as exceptional mechanism to solve the disputes, which is true actually in most of the decisions we've been through. Although actually I've seen one of the decision by the Dubai Court of Cassation 5 years back. It's a lovely decision actually, where the court decided that arbitration and court, they are parallel mechanism to solve the dispute. It's a lovely decision. I've never seen any decision since that time. The other problem, in my view, actually, we have a wonderful legislation, the arbitration law. We have a wonderful community with the practitioners, actually. We have 2 courts, onshore, offshore. In my view, actually, most of the issues that we are facing with the decision which backward us is the judges themselves. Actually, in an event in Arbitration Week, if I ask here how many judges we have among us, no one. So they are not, I don't want to blame them, but part of the problem that they are not willing to come and share the knowledge with the practitioners and to learn the recent developments, at least what's happening outside. The other problem, the problem with the judges actually, which lead to the wrong decisions, they are not willing to think beyond the legislation. For example, they will, in one sentence, they will say that New York Convention said, I should apply the procedural rule of the country. But on the other hand, actually, there is a provision within the New York Convention said, if there is any other convention or legislation, you can use it, which has better provision than the New York Convention. I've been through one decision recently by the Court of Appeal, which is a positive one about the consolidation. And here, when I'm talking about thinking beyond the law and the regulation, the court basically, one of the challenge was that one of the parties said the court cannot, or they approached the court to nullify the decision of the tribunal, where the tribunal decided that they don't have the jurisdiction to consolidate the disputes. And they had a reason. They said because under the DIAC rule, we don't have any provision dealing with the consolidation and even the federal law. The court said, no, sorry, the tribunal is wrong. You should go to the Civil Procedure Code because the governing law of the dispute is the UAE. So under the civil procedure, you have a provision dealing with the consolidation. This is what we said that they should think beyond the law. And it's very rare, actually, where you will find the court thinking beyond the law. The final point, I wish one day we would reach to the level where the legislation will be amended based on the principles of the courts and not the vice versa. Similar to what's happening in France, for example. We shouldn't wait for the mistakes by the court to amend the law. It should be the opposite way around. Thank you.
That's amazing,
It's really interesting.
Yeah, no, and thank you, Hassan, for your valuable inputs, because as we all know, he's a very well-known practitioner here, and it's very interesting to hear your insights. And I'll ask you to share copies of those judgments later for my purposes.
I think that is, I mean, just one comment to that. I think because there is no sort of formal court reporting, often what gets reported in the media is, or in the sort of legal press, are the decisions that go against what we might expect or like to see. We perhaps don't see all the decisions that are sort of less interesting because they're just applying the rules as we might expect to see it. There was an exercise in Saudi Arabia when they were, you mentioned before, looking to sort of promote arbitration in that jurisdiction, where the SCCA went back and looked back over sort of decades of case law. And actually all that those of us outside of Saudi knew about were the decisions that were sort of against arbitration as a means of resolution. And actually, when they went back and did this research, there were dozens of cases in favour of arbitration, whether that's staying court proceedings in breach of arbitration agreement, enforcing arbitration awards, whatever measures to help support the arbitration. But those are things you don't necessarily hear about. So perhaps it's not always as bad as we think it might be.
Yep, no, 100%.
Can I just echo that one point about engagement, because I think that's a really significant point about the lack of engagement between perhaps the judiciary and the practitioners. I have to say, I mean, from my perspective, that's that level of engagement is why I find these sorts of events so important and so useful to me, because I get insights like this into areas where I really only can see some snapshots. You know, you have in this room experts in the field, in various different fields in lots of different jurisdictions, and sharing that knowledge is absolutely critical, it seems to me, and I totally agree that it would be much better if the judges could be somehow brought into the fold.
I know we're running short of time, but I believe in the rule of three. So does anyone have one last question? And if possible, keep it brief. Otherwise, I have one for Lara, so I'll leave it to the audience. No? Okay, one last question. There you go. All right.
Saved.
If you could keep it brief and also introduce yourself, please. Yeah, thank you.
Hi, I'm Olivia from HKA. I'm a consultant. Are you seeing a skills gap that's growing in younger generations in your respective fields because of the development of technologies? I mean, we talk about AI and all sorts of different levels of intelligence, but we're really lacking soft skills and human empathy and emotional intelligence, which is really valuable. I know it's not necessarily related to arbitration, but generally, I was just wondering.
Can I just say something? I was catching up with my friend Mohammed Abdel Wahab outside, and we were talking about virtual hearings. Sorry, I'm going to say what you just told me, Mohammed. He said, and that answers your question by giving an example, that he was in a hearing, and a junior associate asked him, "Can you tell me what a hearing in person looks like?" And he just told me the story like an hour ago. And I was like, wow. So that answers your question. I'm not sure where we're going with the junior generation. I'm sure the junior generation will find its way. But this is what you get in terms, I think, of situations at the moment. And it's a shame, I think.
There's also a bit of a skills gap, isn't it, the other way? I mean, as much, Olivia, as the junior sort of end of the sort of professions, I guess, are sort of not getting those for one-on-one experiences, and hopefully, now that we're all sort of come back from the pandemic, that will be addressed to a certain extent. And there's also a skills gap at the more senior end when it comes to actually using the technologies. And I think there's arbitrators and practitioners have done a lot over the last few years to sort of educate themselves in that. But I think there's still work to be done. I mean, I know it's people in my team who educate me how to use technology.
Not me. But sorry.
No, I was just going to say, I mean, from my perspective, I'm not sure I necessarily see the sort of skills gap that you're referring to. I mean, I did an arbitration last week, and I was appearing in front of one of the arbitrators had been appointed by the LCIA. She was, I think, she was a barrister, 2 years cool, and she was excellent. I thought she was engaged, asking insightful, difficult questions, clearly on top of the material, and I would have no hesitation in using her again as an arbitrator and putting her on the list. So I'm not sure. I do think you're right, though, that there might be a skills gap at the other end. I have to say
exactly.
that moving off paper, which I've now done almost completely, was terrifying. But so hopefully others will be able to do it as well.
I'm sure consultant companies will start creating trainings.
I'm sure. There'll be an industry, no doubt.
For arbitrators.
Yeah, no, I'm glad you asked that question, because that was going to be my question. Not put in the same way about skills gap, but something similar for younger members. We just have one last question because it's raised virtually. If you could answer in a very 30 seconds. Dr. Sezen Aktepe sends, should legislations include a time limit for arbitration? And I know the answer is most of them do, but I think is it generally what you would see and what you would expect for arbitrations to conclude?
I think it has to be flexible. I think that you just can't seriously lay down a one-size-fits-all time limit. Some arbitrations are incredibly complicated and require multiple phases, and to fit them all into, whatever, 6 months or whatever your time limit is just not going to be possible and do a proper job. I don't think one can do that.
But I do think having a sort of default position where you've got to justify a long
period,
I
agree.
It sort of makes sense. And I come back to a point that was discussed earlier in terms of arbitrator selection and the database of material people the ITC have about arbitrators. I think strikes me one of the factors looked at more and more is the time it takes to issue an award. And actually, if you're an arbitrator and it's taking you 6-9 months to issue an award, that is a sort of strike against you. So I do think there is a balance to strike. But no, I agree with Tom.
Great.
I think the rules also do the job, actually. So
No.
and give the flexibility while doing, the job. Yeah.
Yeah,
So the arbitration rules.
Great. I think if you leave us, we'll discuss all day here, but I know we've run out of time. Thank you all, and most importantly, thank you to all our panelists for a very, very enriching and enlightening discussion. And I look forward
Thank
to
you, Aaron.
seeing
Thank
all.
you for organizing and for great job.
Break. We'll reconvene at 11:50. Thank you all.
Went well?